Every government has power, right? But what stops that power from going unchecked? Well, today, we're cracking open the state's official rulebook to get a handle on the guardian of good governance, administrative law.
I mean, just think about it for a second. An official denies your permit. A new regulation suddenly upends your business. It feels wrong, maybe unfair. What can you do? Who's there to check their power? This is where this whole topic gets very, very real.
And the answer right there is administrative law. It's the entire system built to make sure the huge machinery of government actually plays by the rules. It's not so much about what the laws say, it's about how those laws get used by public officials. This is the bedrock for making sure things are legal, fair, and that someone is held accountable.
What's really fascinating here is that people have argued about the purpose of this rulebook for ages. There are two big ideas. The red light theory sees the law as a cop on the beat, basically saying stop to the state to protect our liberty. Then you have the green light theory, which sees the law more as a set of traffic signals, helping the government run smoothly and get things done for the public good. The truth is, most modern systems are trying to do a bit of both.
Okay, so if administrative law is the playbook, who's the umpire? Who gets to call foul play? Well, that massive responsibility falls to the courts through a process called judicial review. Judicial review is, without a doubt, the main tool for keeping everyone in line. It's the way the judicial branch can look at what the executive branch or any public body is doing and check if they've stepped outside their legal powers. Now, this is a super important point, so listen close. A judicial review is not the same as an appeal. An appeal asks, was this the right decision? A review is totally different. It asks, was this decision made in the right way? The court isn't there to give its own opinion. It's just there to check if the process was legal, rational, and fair. Big difference.
And this quote from Lord Mustill just nails it. It perfectly captures the tension and the necessity of what the courts are doing here. You know, for the rule of law to actually mean something, courts have to be able to step in and make sure the executive is following the very laws Parliament wrote. It's a cornerstone of checks and balances.
So, when the courts are doing a review, what are these rules of fair play they're looking for? This gets us to some really fundamental ideas that lawyers call natural justice. They're principles so basic, they're considered universal,
and it really boils down to three pillars. First, the person making the decision can't be biased. Second, you have to get a fair chance to make your case. And third, they have to tell you why they made the decision. Together, these things are what make a process feel just and transparent.
So what actually counts as bias? Well, it's broader than you might imagine. The obvious one is pecuniary bias, a financial stake. If you're voting on a new building and you own stock in the construction company, that's a no-go. But it also covers personal bias, like ruling on a case that involves your best friend or your worst enemy. And there's even departmental bias, where an official is just so locked into their department's way of thinking, they can't possibly be impartial. The whole point is to make sure the scales of justice are actually balanced.
Okay, but what about all those times when an official is given discretion, the power to just make a judgment call? It has to happen in modern government, but it's not a blank check. Even that kind of power has limits.
The courts have a really powerful checklist for this. They ask things like, was the power used for an improper purpose, like using a public health law to shut down a political opponent? Did they consider irrelevant things, like denying a license because they didn't like the person's haircut? And then there's the big one. Was the decision just completely fundamentally unreasonable?
And that idea of unreasonableness is defined by this legendary legal standard called the Wensbury test. And let me tell you, the bar is set incredibly high. It's not enough for a court to just disagree with a decision. To fail this test, a decision has to be so outrageous, so defiant of logic, that no sane, reasonable person could have possibly made it.
All right, we've talked about all these big principles, but how do they actually work in practice? Let's bring this down to earth and see how this universal blueprint for justice gets applied in a specific country. We'll use Nepal as our case study.
This is where the rubber meets the road. In Nepal, the power of judicial review is baked right into the constitution itself. And this isn't just theory. You can see it in action. Think about the Rajendra Prasad Dahakal case, which was about people who disappeared during the armed conflict. The court actually used its power to order the government to investigate, showing how these abstract legal tools can be used to protect human rights and demand accountability.
So when a court says, yep, that was unlawful, what can it actually do? It's got a whole toolkit. It can issue a quashing order, which basically voids the bad decision. It can use a mandatory order, which forces an official to do their job. It can even issue a prohibiting order to stop an illegal act before it happens. Each one is a different way for the court to step in and fix things.
So in the end, administrative law is this living, breathing thing. It's this constant tug of war between having a government that can get things done and protecting the rights of every single person. And as the world gets more complicated, with things like AI and global health crises, the big question we're all left with is this: how do we make sure the Guardian's playbook is always sharp enough to keep power in check?